coming into our newsroom. If you notice, our verdict clock there in the bottom right hand of your screen has stopped in the California versus Maya Hernandez case at 9 hours, 30 minutes and 49 seconds. We understand there's movement in the courtroom and that this jury might be deadlocked at this point.
And I'm shocked because it's the evidence that was presented about one of her children dying in a hot car because she was getting in to get a treatment, cosmetic treatment done. Let's go into court and see what's happening.
Feel that would be pointless. Is that accurate?
Yes.
For the group, is that accurate?
Yes.
Yes. No one's indicating yes. Okay, so I'm going to ask each one of you the same question. It's actually multiple questions in one. If any of these things you believe would be helpful, let me know. Pardon me? Yes. Is there anything further, I'm just asking juror number one right now, we'll go down the line all the way. Is there anything further closing argument on a specific issue from the attorneys, any clarification of the law by me, any questions that you have of the court that you think would be of assistance in reaching a unanimous verdict? 2, 3, 4, 5, 6, 7,
No.
8,
No.
9,
No.
10,
No.
11, 12. Counsel satisfied?
Yes.
And you have reached a verdict as to counts 3 and 4. Is that accurate?
Yes.
You hand the verdict form to our bailiff and we'll take the verdict on those 2 counts. I know you've had multiple days deliberating, so the one thing I'll just need you to do is even though you didn't fill out anything for count 1 because we know why, we just need a date on that first page. So we'll hand that back. Do you have a pen with you?
I know.
We'll give you a pen. Our bailiff has one. You just fill in the date. Today's date is the 18th.
Just on the first page.
Yes. And you can give the verdict form to the summary.
Superior Court of California, County of Kern Metropolitan Division. The people of the state of California versus Maya Hernandez, case BF 205702A, verdict. Bakersfield, California, December 18, 2025. Third count. We, the jury, impaneled to try the above entitled case, find the defendant, Maya Hernandez, guilty of child abuse likely to produce great bodily harm or death of Emilio G. in violation of Section 273A, paren A of the Penal Code as charged in the third count of the information. Signed, foreperson. Finding on Penal Code Section 12022.95, death of a child. We, the jury, impaneled to try the above entitled case, find it to be true that Emilio G. died as a result of the crime, charged in count 3. Signed, foreperson. Fourth count. We, the jury, impaneled to try the above entitled case, find the defendant, Maya Hernandez, guilty of child abuse likely to produce great bodily harm or death of Mateo G. in violation of Section 273A, paren A of the Penal Code as charged in the fourth count of the information. Signed, foreperson.
Thank you. For the jury, is that your verdict that has just been read?
Yes.
Would either side like me to poll?
No, thank you.
Any legal reason why the court should not accept the verdict that has been reached?
No.
The court does accept the verdict and lodge it. I am declaring a mistrial as to count 1, which then necessitates a mistrial as to count 2 being a lesser included offense. So for the jurors, I have one final jury instruction for you, then we'll have you return briefly back to the jury room, and then after that, you'll be free to go. You have now completed your jury service in this case. On behalf of everyone involved in this trial, thank you for your time and your effort. Now that the case is over, you may choose whether or not you wish to discuss the case and your deliberations with anyone that you want. I remind you that under California law, you must wait at least 90 days before negotiating or agreeing to accept any payment for information about the case. Let me tell you about some rules the law puts in place for your convenience and protection. The lawyers in this case, the defendant, or their representatives may now talk to you about the case, including your deliberations or verdict. Those discussions must occur at a reasonable time and place and only with your. Please tell me immediately if anyone unreasonably contacts you without your consent. Anyone who violates the rules violates a court order and may be fined. I now order that the court's record of your personal juror identifying information, including your names, addresses, and telephone numbers, be sealed until further order of this court. If in the future the court is asked to decide whether that information would be released, notice would then be sent to any juror whose information is involved. You may oppose the release of the information, and you may ask that any hearing on the release be closed to the public. The court would then decide whether and under what conditions any information may be disclosed. I want to thank you again for your service. This is a very difficult subject matter in this case, and each of you were willing to serve as jurors, and we commend you for that. Wish you all happy holidays with your families. Good new year. This time you are officially excused, but we'll have you step back briefly into the jury room, and then we'll excuse you from that. Okay? See you in just a couple minutes.
Wow, big news, breaking news from this jury. First of all, 4 counts against Maya Hernandez. The first 2 counts, the jury is deadlocked. That means they can't reach a unanimous decision. Counts 3 and 4 are the child abuse likely to produce great bodily harm or death. And the 2 deadlocked on, the first is second-degree murder, which includes the unlawful killing of a human being with malice, and the involuntary manslaughter is either without malice or commission of a lawful act that was done without due caution and circumspection.
Yeah, bit of a shocker.
Completely.
I thought certainly either the second-degree murder or certainly the involuntary manslaughter, where we're talking about a conscious disregard for human life for that second-degree murder, it seemed to fit those facts. And as far as the child abuse producing great harm or death, in the case of Emilio, where he died, she's facing 25 to life.
Yes.
So she's not out of the woods yet.
No.
And for the second child, Mateo, where it was great bodily harm, anywhere from 2 to 6 years. So I don't know if it's fair enough to call it a big victory, but certainly a victory for the defense.
And I'm based on the facts. We know this. We know that one of the 2 children died in the car that was too hot. We know she left the children in that car. We know she went in for a cosmetic procedure. All of that together, I am surprised they could not reach a verdict on counts 1 and 2.
The only thing I can think of is they gave a lot of deference to the fact that A, she testified.
Yes.
And 2, she did leave the air conditioning on and didn't know that the car would shut off after an hour. Left them with milk, cookies. So again, doesn't make it right, but I'm just trying to figure out why this jury has
And you were right.
with those 2.
Factually, what you just said could sway people in a jury. So I think that may be where they're stuck. All right, stand by. We have to squeeze in a break. When we come back, we're going to get you back inside the courtroom for more of this case against Maya Hernandez. Hung jury on 2 charges, guilty of the other 2 charges. We'll be right back.
I'm going to ask you a lot of intensely personal questions.
From the crime scene to the courtroom, this is Victim to Verdict.
Everyone has this heightened sense of anticipation.
What a day here at Court TV.
Fireworks both inside and outside the courthouse.
Let the cameras roll.
Welcome back to Court TV Live. We want to get you back inside the courtroom in California in the case against Maya Hernandez. Michael, 4 counts, a hung jury on counts 1 and 2, counts 3 and 4, guilty charges.
Yeah, just again, a little bit of a shocker. You and I both thought that the top charges kind of fit the circumstances, but obviously this jury disagreed.
That's right. Let's go back inside for more from that courtroom.
In this case, we do have a conviction on 2 counts plus the finding as to count 3 of death. And that would necessitate, obviously, a report from probation. We do not know at this point whether the people intend to retry counts 1 and or 2. Do counsel wish this to be set for a sentencing date or for an intermediate status date? Or you want to wait a couple minutes, one of the two of you talk? And let me know.
I think we're both in agreement for a status date, Your Honor.
Correct. Okay. Can we do that in January?
Yes. Sure.
How about January 12th, Monday?
That's fine for me.
Fine with the defense.
We have another trial regarding that trial that day, which gives plenty of time to talk about whatever you want.
I may be sent out in another trial, I do not know.
Whatever trial you're sent out in, they'll need to be done.
I understand.
Okay. Right. So we'll set it for status only as to whether counts 1 and 2 will be retried, and or setting a sentencing date for January 12th, 8:30 here in Department 4. Mr. Hernandez, you have a right to be sentenced within a statutory period of time and to go to trial if those counts are retried within a statutory time. At this time, do you agree to waive time to January 12th plus 60 court days for sentencing and or retrial? Counsel Jones?
Counsel Jones.
Is that acceptable with the people?
Yes.
Okay. And you remain in custody at this time with bail as previously set. And that ends our proceedings for today. We'll have the audience next. Thank you.
Sentencing set for January 12th, 2026.
Actually, not sentencing, status hearing.
Thank you. I apologize.
Because they still have to determine whether they want to come back and try her again.
Thank you. Thank you for that clarification. Very different things. And we know on that child abuse resulting in death, she's facing 25 years to life. Yeah. Pretty serious sentence. Still with us, criminal defense attorney, former prosecutor Jack Rice, and joining us now from Tampa, Florida, former prosecutor and constitutional attorney Chrisanne Hall. Chrisanne Hall is the constitutional attorney. What do you think when they've deliberated 9 hours, 30 minutes? We now know that they were deadlocked on the charges of second-degree murder and involuntary manslaughter.
Well, I think it really shows us that what we have is a highly divided jury. I mean, deadlock means they couldn't come to a decision. And that is going to weigh heavy on the prosecution. As a former prosecutor, I can tell you, even at the status hearing that's coming up, are we going to refile these charges? I personally would take that as a clue that her testimony on the stand was very persuasive, and that the jury, even though they found there was child abuse, that they couldn't raise the standard to murder or homicide.
Yeah, I would have to agree, Chrisanne. And you know, it's interesting because, Jack, I think the issue, and I felt it might be an issue throughout, was this whole idea of intent. Prosecutor went all the way around to make sure that they explained what they meant by intent. It was implied intent, but that word intent is there, and I think perhaps maybe there's some mothers or even anyone, a father, anyone who has children, just maybe struggled with that intent because they just really rejected those out of hand.
I think they did, Michael. And I think especially the fact and that piece of evidence where she talked about the car shutting off and not knowing that the car would shut off. Yes, clearly child abuse, no question about that. And yet the notion that she gives them milk, she gives them treats, she leaves the car on, she leaves the air conditioning on, I think all goes to that. But what I do think is interesting and what I think is coming, and I see this, again, been doing this as long as I have on both sides of the aisle, is I think what you're going to see is pressure from the prosecution on the defense to resolve this case for a certain period of time, and they're going to try to ratchet it up rather than the notion of coming back and having to try counts 1 and 2 again. So they're willing to dismiss those and they can wrap this entire thing up.
Let me throw that back at you, because my question about that, Michael and Jack, I'll ask you, but Michael, I'd love to hear from you as well. Is 25 years justice? Because I would think if I were the defense, I'd say, sure, we'll agree to 25 years and let's dismiss those others. And I assume the prosecution would probably say, we're going to want more than that. What do you think, Jack?
Me first, Jack.
Yeah, go.
That's why you're not a defense attorney.
That's fair.
I'm not agreeing to 25 years in this instance under any circumstances.
That's my boy right there.
But
Exactly.
it's 25 to life.
I understand, but I'm not going there in this particular instance. I would, at this point, tell them, go ahead and try her again.
Oh,
but anyway,
my
Jack, love to
gosh.
get your thoughts on that.
Now
Then we'll check in with you, Chris.
Michael, I'm with you. 25 years is a lifetime. It's a lifetime, and the thing is that if we're looking at 25 years, the worst that's going to happen is that. Why would I negotiate that out? I'm not negotiating against myself. If I'm coming in at that 10, 12-year mark. I'm coming in way down below that with an agreement to dismiss counts 1 and 2 and never retry them. The idea of going to 25, absolutely not. I'll roll those dice again because I had the jury the last time. You screwed up that time. I'm going to come at you again, and this time harder.
And I know we have to go to a break, but Michael, I guess I was thinking if it's 25 to life, you can't even agree to less than 25. But you're saying you could agree to less than 25.
You could agree. You could make a deal. It's absolutely, you can make a deal. No
This
question.
is why I'm not a defense
Chris, quickly
attorney.
ring in. I got a couple of, about 30 seconds or so.
Yeah, I'm on your side. I think that the prosecution's going to try to push for a negotiation that way. But if I'm the defense attorney, and I'm even going to say this at sentencing to the judge if there's no agreement to be made, the jury already came back and said, this is not a homicide. This is not a manslaughter case. Now let's deal with it as it is, child abuse.
Absolutely.
I'll remain the judge and listen to all of your compelling arguments because they've all been better than any of the things I've said.
You can just ratify
Yes,
the deal we come up with.
Yes, please.